When it comes to immigration, about the only thing Democrats and Republicans agree on is that the current system is broken. A record number of people are crossing the border, and immigration courts can't process them efficiently. That's led to a huge backlog of pending cases, which isn't in anyone's interest. How did the courts get to this irredeemable point? Well, it was a perfect storm of compounding factors. On the simplest level, the backlog exists because there are a lot of new cases and not enough judges to handle them. This problem dates back to 2008, when the backlog started to grow. Even though then Attorney General Alberto Gonzales planned on hiring additional judges in 2006, a lot of the positions were never filled. Then, beginning in 2011, the budget sequester meant that no new money could be allocated for hiring. So the number of judges and support staff remained roughly constant, while the number of new cases grew annually. But if the gap between the number of judges and cases was the only issue, judges would also have been overwhelmed when there was a surge in arrivals back in 2005. Instead, judges then quickly handled those cases without adding to the backlog, completing a record number of cases per year. This time around, things have been very different. Instead of handling more cases in response to the surge of new migrants, judges are completing far fewer. It's not because judges are lazier, it's because the cases are more complex. In 2005, most of the new arrivals were Central American farmers who'd been displaced by U.S. trade policy, and Brazilians taking advantage of a lax visa policy with Mexico to get to the U.S. They had a weak legal claim to stay in the U.S. and were quickly deported. During the Obama administration, by contrast, the types of cases changed, as did the policy for how to handle them. Starting in 2014, when there was an influx in the number of families and minors crossing the border, the Obama administration moved those cases to the front of the line. That sounds like a good idea, but it often meant that families had to come to court before they'd secured representation or had time to collect the necessary documents to prove their case. That actually made cases take longer to process, since judges would have to offer what are known as continuances. The family would be allowed to come back to court at a future date when they were ready, which meant the final resolution of the case would be delayed, seriously slowing down the courts. And when the Obama administration expanded eligibility for asylum to include gang and domestic violence, the courts slowed down even further.
If you had 100 cases of Christians from communist China, where persecution of Christians is very clear, or you had 100 cases of Central American women who've been abused by their partners, it's going to take much longer to adjudicate the 100 cases from Central America. Those cases take a lot more nuanced analysis in order to determine whether the asylum law fits them or does not fit them.
For Judge Marks, the backlog isn't just due to lack of resources or the types of cases, but the structure of the court itself.
You think of plea bargaining as a way to dispose of relatively non-controversial cases. That basically doesn't exist in immigration law.
The closest thing in immigration court is called administrative closure, which allowed judges to remove low-priority cases, like, say, an undocumented person who'd been caught running a stop sign, from their dockets, in order to devote more time to serious cases. This was a tool increasingly used over the course of the Obama administration, but it never covered more than a small fraction of new cases. And in any event, Trump's first Attorney General, Jeff Sessions, eliminated its use. And because the Trump administration wants to deport all undocumented people, Sessions reopened over 350,000 previously closed cases, which will only make the backlog worse. The Trump administration has put several measures into effect to reduce the backlog. They've hired a staggering number of new judges, reduced asylum eligibility, implemented quotas so that a judge's performance is measured by the number of cases they complete, and restricted the use of continuances. This will undoubtedly speed up the courts, but the question is whether it'll lead to a well-functioning or just system.
The law is complicated. We're required to give people the opportunity to present the evidence that they feel is required. And if we don't give someone their day in court, we can be denying them due process.